getting people into guilty convictions and guilty pleas at a rate, I think that 50%, and I'm not exaggerating a bit, and I've been in jail, and when I'm in jail, you know, I'm not sitting there doing nothing. I'm taking interviews. I talk to people. I'm talking to prisoners. I talk to real honest-to-goodness criminals who take guns and shoot people, and I interview them. Why do you do that? Why did you deprive that man of his life, liberty, and property? Don't you recognize that that's a basic violation of the common law? Don't you understand the law that says thou shalt not steal, thou shalt do no murder? Why do you act that way? And many times, oh, I don't know, well, I just needed the money, and well, well, maybe some of those people need to be locked up. But I also talk to people who are entrapped, people who are just citizens like you are, who are just victims. And they're faced with a DWI, and the fella had 3 beers, and he was no drunker than you or I, or doing anything any different than you and I would do, and now he's faced, for the 3rd time in this state, with a felony. I'll put him in penitentiary. Cases like that, just, you know, you can't believe how many there are. These people don't understand their rights. If they understood their rights, they wouldn't be convicted for those crimes. Any citizen who will go into the court with a little knowledge and a little understanding can win the case. Judges are sitting there willing to listen. Now, there's a lot of judges that are probably not too willing to listen. They're probably opinionated and probably have a lot of prosecutorial bias. But, you know, if I sat on the bench 8 hours a day and listened to 100 people a day coming through bleating like sheep and pleading and whining and wheedling and oh please and lying, you ought to listen to the citizens out there lying about their traffic cases. Well, I wasn't going 40, and well, you see, the reason that I was, because I was late for work, and well, I made that turn, but I thought it was right, and one thing and another. You know what I tell them? I was driving 80 miles an hour in a 55-mile-an-hour zone. So what? Yeah, that's right. So what? Did I run over somebody? Where's the victim? Where's the corpus delicti? Where's the crime? Where's the contract? Where's the penal clause? I'm not guilty of any crime. All right? That's what judges want to hear. You know, judges in the appellate courts don't want to listen to lies and the bleatings of sheep. You know, like your 10-year-old kid coming in there sheepishly, you know, well, Daddy, I didn't wash the dishes, and you see the reason that I didn't wash the dishes, Daddy, was because. Not interested in why because. You knew you had to wash the dishes, you knew you had to make your bed, you knew that you had to comb your hair, and you didn't do it. And that's crime in this house. And punishment ensues. And that's the end of the argument. All right? Well, what if you're not guilty of any crime? What if you did wash the dishes? But, Dad, you didn't tell me to dry them. Dad, you said wash the dishes, and the dishes are sitting there, and they're washed. But you didn't dry them and put them away, sweetheart. That isn't part of the law, Dad. Oh, okay. Yeah, that's right. You're not guilty then, sweetheart, because you didn't dry them, because I didn't tell you to dry them. There was no obligation to specific performance in that case, then, is there? All right? Well, let's go on here. There's your Fourth Amendment. There's your search and seizure law report. Do some study on that. Remember that the degree of excellence that you're going to achieve is going to be based upon how much time, effort, and energy you put into it. I learned how to fly some years ago, and I noticed that the better, more knowledgeable flyers practiced a lot more, read a lot more, talked a lot more, did a lot more. And those that were kind of, you know, routine, average Joe Schmucks, well, they did just what they had to do. What I want to do is to create students who are superior to me, and I've already done that. I have students that come in here that write paper and ask me to grade it, and I look at it and say, sir, I cannot grade your paper because I can't write anything that well. And that's what I want to make out of you. You know, I'm not God. I'm not the best lawyer in the world. I'm sure F. Lee Bailey probably just talks circles around me. But the moral of the story is you get out of it what you put into it. So if you want to be an average Joe Schmuck, well, then just do an average amount of work. If you want to be superior, get in there and do something about it. Because when you finish this course, you are going to be a lawyer with a rating of competence greater than any public defender that I have ever met. You're going to be far greater than any public defender and something less than 10% of the trial lawyers in America. You're going to be rated somewhere, as Chief Justice Berger would rate you, less than the 10% of competent trial lawyers, but greater than the 90% who are incompetent, because you're going to become a competent pro se. All right? Fifth Amendment. Let's read on. We're on page 28 of this little book. This comes from the National Americanism Commission of the American Legion. All right, we're on page 28. Here's your Fifth Amendment. Now, I read through it. Let's study it a moment. No person. Let's look at this word person, because the word person covers, remember in status, it covers a great number of individuals. We're all persons, but we're not necessarily persons of the same category or status. Corporation's a person. Bank is a person. I'm a person. A felon is a person. A crazy person is a person. An incompetent or an insane person. They're persons. They don't all have the same capacities. See, an insane person does not have the same political capacity that you and I have. He maybe can't vote. All right, so no person here shall be held to answer for a capital or otherwise infamous crime. There's a comma there, and I want to stop for a moment. Well, obviously, the context or the language, then, this has got to apply to a natural person, because remember that a corporation is nothing more than a piece of paper. All that is a file folder, like this, in your Secretary of State's office. That's all a corporation is. Or a trust or a foundation or some other paper fiction. May have the right to sue and be sued, may have the right to own property, but it's not a person in this context. Now, here we're talking about a person. No person shall be held to answer for a capital or otherwise infamous crime. Take a look at the word infamous crime in Bovier's Law Dictionary. Because Bovier's Law Dictionary of 1870, which we sell and we use almost exclusively, tells you plainly that's a very serious crime. That's a felony. See? Now, a felony is called this infamous crime and requires what? Listen to this. It requires, unless on a presentment or indictment of a grand jury. You know, I've been charged with felonies in the state of Idaho twice, and they're attempting, or have in the past, attempted to prosecute me by what's called complaint or information. Okay, pull out your dictionary. You should have a Bovier's Law Dictionary. Excuse me. You'll find out here that the grand jury, then, is your protection against your government. You see, when our founding fathers set up our Constitution, they said, okay, government is over here, and we're going to put a shield between the government and between the citizen, and we're going to call that the grand jury. So we call 17 to 23 people to the grand jury, and they take a majority vote. They listen to some facts and figures and evidence. The prosecutor says this guy did this and that. You come into the grand jury and say, wait a minute, I don't want to go to the expense of a long, drawn-out trial to try me for this crime. Let me tell you what happened, and this is where this came down, and this is called a grand jury investigation. We're going to investigate this and find out whether or not there's probable cause to believe that George Gordon committed this crime. It may be that he was just demanding his rights and that there's really no crime and that this policeman over here is just vicious and malicious and trying to teach Gordon a lesson. Well, that happens a lot of the time. Now, when we're talking then about protection by the grand jury, that's what you're looking at here when you're looking at no person shall be held to answer for a capital or otherwise infamous crime. Now, all infamous crimes are felonies. And let me tell you, in the state of Idaho, we don't prosecute people in this state with indictments of a grand jury. We haven't had one of those here for 18 years. Now do you begin to see why I'm telling you that, our prosecutors don't obey the law. They have usurped the law. They've usurped power that belongs rightfully to we the people in our grand juries to protect we the people from these malicious prosecutions that are occurring here. And so, until we get our grand jury back, this is called a major federal question here. And let me tell you, this major federal question should be raised by motion and brief every time you have a case. I don't care whether it's a parking ticket. I raise my Fourth and Fifth Amendment exclusionary rules, and especially, when you have an indictable misdemeanor. They hung a heavy case on me the other day, and I asked the judge, well, let me ask you this. Is this an indictable misdemeanor? Because if it's an indictable misdemeanor, we're in the wrong court. You don't have any jurisdiction here. We have to have a grand jury. Pretty soon they talked about it for a little while and said, well, we think this is probably an ordinary misdemeanor, Mr. Gordon. Oh, ordinary misdemeanor. Okay, if it's an ordinary misdemeanor called obstructing and delaying a police officer in the performance of his duties. Now, what he's really mad about is I went out to jail and they wanted to take my fingerprints, and I became that belligerent claimant in person and said, get a court order pursuant to Davis versus Mississippi. And if you think that you need my fingerprints here, what did you do with the fingerprints you took last March? I had a court order and I gave you the fingerprints in your own statute. Now here's my government charging me under Idaho Code 194812 and 4813 says plainly, if the fingerprints and photograph are on file within the last year, no photograph or prints are needed. Now, why is my government prosecuting me for obstructing and delaying a policeman? Because the policeman's mad because I'm demanding my constitutional rights, and he doesn't like that. He's a slave. He doesn't have any rights. He doesn't know how to claim them, and he's mad at me because I'm demanding my rights. And he's saying, well, if you don't have anything to hide, why don't you just give me your fingerprints? Well, if I don't have any Fourth or Fifth Amendment protections, then there aren't any rights to talk about, and I might as well just go in and play the part of an average Pole or Czech or Russian or Chinese and just be a slave. You know, if you don't exercise your rights, you don't have them. The reason I have rights is because I exercise them. And all that exercise is going to do is create another $2,000 bill for the judicial and the prosecuting system of our county, and the taxpayers will pay $2,000 into the law enforcement growth industry, and I'll rack up victory number 36. That's all that boils down to. I laugh at these fools charging me with these kinds of Mickey Mouse crimes. They're not even crimes. And they don't even get out of the state of Idaho. They all get sandbagged over in the district court somewhere. Some judge takes a look at this. After I appeal it, jury always finds me guilty. Well, what do you expect? You know, all the slaves, you know, well, we have to give our fingerprints. Why shouldn't you? What I'm trying to tell you is that none of you have to give them your fingerprints. Those fingerprints are protected by the Fifth Amendment. I'm going to show you that. So, here is a very valuable out. This is a very valuable rule. If your government wants to take your grand jury away from him, you ought to scream about that. And remember, if you have a lawyer, and this is typically what happens, and this lady whose son now is being charged with first-degree murder, he has a lawyer entered into the case. That lawyer is called the lawyer of record, or the attorney of record. So the man himself, that is the defendant, is declared incompetent. The lawyer now has his power of attorney. The lawyer acts or represents him. Well, the lawyer isn't going to go in there and say, hey, we want a grand jury indictment. He's not going to go upset the apple cart. He's not going to go tell the bureaucracy that, you know, here's this government bureaucracy. He eats out of the same trough they do, out of the taxpayer's trough. He's sure not going to go in there and raise Cain about this Fifth Amendment right. Watch the citizen go in there. You can't throw me out of the courtroom, and you can't disbar me. I'll go in the courtroom and demand my grand jury and create a major federal question. I'll tie that courtroom up for 5 days, and it'll cost you $10,000 to try my case, and then I'll appeal it clear to the U.S. Supreme Court because I've qualified it right from the scene of the crime, and then Ada County can spend $60,000 of their money. And then when I get to Washington, my Supreme Court's going to say, well, I don't know whether Gordon did the act or not, and that's not relevant. Why did you deny him a grand jury? That's the issue. Why'd you deny Mr. Gordon a grand jury? Well, because he committed this felony. He's a real bad man, and he's evil and wicked and terrible and awful, and we've got to get him off our streets because he's dangerous. He goes out here teaching other people how to go in the courtroom and how to win. And he's out here teaching people about rights and teaching people how to be what he calls free, which is his philosophy. Where do you think I got that philosophy? I got my philosophy of law from the Supreme Court of the United States. You think I'm going to be a little better received in Washington than some of these fools in Ada County who are claiming that they're taking my fingerprints as a matter of law? You can't take a man's fingerprints without his permission and consent, and he's got to sign the card and grant that to you. he has to waive his Fifth Amendment protection against self-incrimination to give you those fingerprints. If there's probable cause to believe that your fingerprints are an essential element of the crime, any judge can sign a court order, and then you're in contempt of court. Now you're obstructing and delaying the policeman in the performance of his duty. And in addition to that, armed with the court order, they can kill you and take your fingerprints, if need be. So what I do when I go out to the jail, I say, as soon as you get a court order, I'll be happy to give you the prints. Where's your obstructing and delaying? Look in a dictionary at the word obstruct and delay. Boy, do I love to preach dictionary in the courtroom. You ought to watch the snickers on the judge's face when you go in there and say, let me explain to you, Your Honor, my position. I'm in this courtroom here charged with obstructing and delaying a policeman in the performance of his duty. Before we get into the direct examination and the testimony, let me read into the record the definition of obstruct. Let me read the definition of delay. Let's get in our minds the act that's necessary to perform this crime. Then we'll talk about the intent behind the crime, allegedly. And then we'll go to the United States Supreme Court. In this case, I forgot the exact case citation, but the court's already ruled that any time a citizen in good faith, and this is what you always do, officer, I'm asserting in good faith, Davis versus Mississippi, as my theory behind my actions, and that's why I'm not giving up my Fifth Amendment right to protection, and I'm considering these fingerprints property, and I'm considering them potential evidence to be used against me in a criminal matter. Well, when you go in there and you give them the fingerprints, don't they then put them on the teletype to find out what other crimes or what other warrants are outstanding? I don't want them to know if there's any warrants outstanding for me in Florida and Mississippi and Texas. I don't want them to know I jumped ship in 1965 down in San Diego and I'm AWOL from the Navy. The guy arrested me and brought me in here because my taillight was out, not because I jumped ship. He doesn't know anything about that. He hasn't got any idea, and he doesn't have any business even asking. You see how that goes? That's privacy. Now, either we've all got it, or those of us who do have it claim it, or then we're all slaves and peons. That's the way that comes down. Well, let's go on a little further. There's an exception in the cases of, and we're talking about this grand jury indictment now. If this is, in this state, it's only for felonies. Now, if it's a misdemeanor, you're not entitled to a grand jury, and I'm not claiming that you are, unless it's an indictable misdemeanor. Now, that's another subject matter. Except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. So, if it's wartime, there are some exceptions. Now, let's go on. There's a semicolon. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. All right, that's another subject matter, and you can look at double jeopardy. And there's a set of books. Now, note this down in your notes, and it's called Words and Phrases, one of the more important sections or volumes of law that you're going to know about. Let's say that you wanted to research and find out how many times has the Supreme Court ruled on the subject of double jeopardy. You go to Words and Phrases and you look up jeopardy or double jeopardy, and you're going to find that the Supreme Court has ruled, let's say, 115 times on double jeopardy. And you'll go through and they'll show you all kinds of people who have claimed double jeopardy and argued the case to Washington, and all types of decisions where the Supreme Court has said, that's not double jeopardy in that case, that is double jeopardy in that case, that's not double jeopardy in that case. You'll read those cases, and when you get finished, you'll have a good understanding of how the court is going to rule in whatever circumstance you're in this particular case that you're concerned with. That's the way you try to determine, and I say try, because it isn't just try, that's the way you determine how the Supreme Court's going to rule in your case. I can pretty well predict how the Supreme Court would rule in my case in any particular circumstance, because I've read so many of their decisions, and I have based my lifestyle around their decisions. That's why I'm so confident that when a policeman charges me with obstructing and delaying, I say to myself and I say to my students, I wish I could get that poor fellow into my class. I'd almost teach him free. to give him some wisdom, understanding, and some knowledge of the law so that he doesn't run around here charging people with that crime. Because, if that policeman charged 100 average citizens with obstructing and delaying, 99 of them would plead guilty and pay the $50 fine. That's a fact. And they'd go in and say, well, the reason I didn't give him my fingerprints was because I was so drunk that night and I was scared and I didn't know what I was doing, and that's why I didn't give him my fingerprints, Your Honor, and I'm real sorry, and I'll never do that again, I promise forever. I'll always give him my fingerprints anytime. When I go in the courtroom, that's right, I didn't give him my fingerprints, and I'm not going to start now. So what? Because I'm that belligerent claimant in person, and I'm relying in good faith upon the Supreme Court. I'm not here to practice law. I know the law. While I'm in jail, I'm also trying to gather evidence and information. In these two cases that I'm charged with more recently, you see, there are really no violations of law. But let me tell you, in your county, wherever you are, every time you do a case like this is malicious abuse of power. Trying to prove malicious abuse of power without that policeman's consent and without his confession, etc., is nearly impossible. But let me show you how. Malicious abuse of power, harassment, can be proven through what's called a long train of events. So here's the way you begin to set it up. In the early days, when I was doing a lot of traffic cases and a lot of business, when I won a case, I just took the file folder and said, well, here's another victory, and I threw it away. In the last, I'd say, 18 months, I have saved every case. And these cases will be, well, I don't have one on the desk, but they'll be an inch thick with all of the paper I've filed. And when you get to the end, the prosecutor or the judge will dismiss, or the jury will find you not guilty, or on appeal, you'll get a decision back that says reversed. Or what'll happen, you'll get a sandbag. Now, when a sandbag occurs, that's when they don't reverse and they don't demand your money, they don't put you in jail, they don't do anything to you. And a year goes by and you don't hear from the court, and you file a motion and you demand action on your appeal, and they just ignore you. We call that sandbagging. A sandbag is a victory. You save those until you've got 20. I don't know whether you need 20 or 30, but my logic, reason, and common sense tells me that by the time I've got 20 cases where the city of Boise has charged me with obstructing and delaying, or no driver's license, no registration, no proof of insurance, and all these Mickey Mouse traffic crimes, alleged crimes. You have a crime without intent and without action. I mean, you don't have a corpus delicti. The very term crime in a traffic case is a misnomer. It doesn't even fit. The definition isn't even there. But you get 20 of these lined up. And here you are. On November the 2nd, 1980, I was arrested, and the case was dismissed March 12th, 1981, and you go through 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, until you get to 20. That is a long train of abuses. No conviction, prosecutor's dismissal, dismissals at the motion hearing, sandbagged. Then you sit down with some of your other more knowledgeable, and this will take you 3 or 4 years to do this. Or it may take as little as 2 years. In my case, I've got 4 cases in the month of January alone. I was kidding some of the people here at the school. I said, at the rate I'm going here, I'm going to do about 35 or 40 cases. I'm going to win 35 or 40 more cases this year. I'll probably win more cases in 1983 than I've won in the last 5 years combined. That's the way I see that, if the trend goes on. When you've got about 20 cases, you prepare a $20 million major federal question civil rights action against your city and all of these policemen, all these government and county officials, and you take it and you serve it right on the governor and the Secretary of State, just like our founding fathers did with King George in the Declaration of Independence. That was a letter to King George and said, a long train of abuses, sir, have prompted our action. And then sue him for $20 million. By the time you've got 10 or 15 people, and I'm not recommending that you form some group or society or association. You should just, in our case here, I don't belong to any groups. I don't need any crutch. I can demand my rights by myself. And I'm capable of going into any court in the United States and arguing my position any time of the week and take anybody on. And that's where you've got to be. But you get a bunch of other citizens in your county, and they save their cases until they've got 20. And believe me, you take the license plates off your car and throw your license away, or not throw it away, but send it back. It won't take you long to get 20. And with a little knowledge, it won't take you long to win 20. Then let's go in like they did in Alabama and Mississippi and North and South Carolina. And then let's straighten your county right out. You watch those judges snicker when they get those major civil rights actions. Sue your county, sue your policeman for $20 million and get 20 of those cases going. All you have to do is win one of them for $1 million or $2 million, and some of these counties in this state would go bankrupt. In fact, I'm not so sure, but what the county I'm in right now, which is the biggest county population-wise, if they had a $2 or $3 million suit, might be like South Tucson, Arizona. They'd be bankrupt and have to start selling off the citizens, that is the slaves, the taxpayers' property, to pay the suit. And boy, they got federal judges down there in Arizona telling those people in South Tucson, you're going to pay that guy. That's right. Now that's what I've got in mind, and that's what I'm recommending that you do. Save your cases and prepare it. Gather evidence, gather information, gather witnesses. Going on here in this Fifth Amendment, it goes on this. Now this is the real crux of this Fifth Amendment. It's called, nor shall be compelled in any criminal case to be a witness against himself. Now we're going to talk about that at length in Miranda versus Arizona, and you have that book here in the packet. Miranda versus Arizona is the most valuable civil rights case to come out of this thing called the exclusionary rule, or to become a part of it, or come out of our Supreme Court, in my opinion, in this century. And it's a part of the Boyd, Weeks, Carroll line of exclusionary rule cases. It is a crucial Fifth Amendment case. And I recommend that you read the entire case. It's one of the longest cases in Supreme Court history. That's how what's called landmark case it was. It was a very important landmark case. It didn't decide anything new. The Fifth Amendment's been around since John Lilburn in 1637. Take a look at what Earl Warren had to say about John Lilburn. He'll go clear back to the 16th century and just come forward and say, this is the way the Fifth Amendment's always worked. And we're not changing anything. We're just telling you exactly here in Miranda what's always been the law. It's just that the policemen haven't been obeying the law. And so every now and again we have to get the police spooked a little bit, tune them up. Okay, you have to stop shooting niggers off their front porch. That's the problem down in Alabama. They had sheriffs down there shooting black people right off their front porch, for crying out loud. Some of those black people down there in the South said, wait a minute, we're going to put a stop to that. And what we up here in the North are going to have to do is stop these sheriffs up here from throwing citizens in jail because they don't have driver's licenses, because they want their constitutional rights. That's what that boils down to. Well, let's go on. Nor be deprived of life, liberty, or property without due process of law. Now, due process of law is a 14th Amendment guarantee, and I'm going to show you what due process of law is as we go through it, because, boy, I'm telling you, we're going to use due process of law and equal protection of the law until I wish they'd never heard of us. Now, we're entitled to that, but we don't get that. You don't get due process and equal protection from the IRS and your state tax commission and these bureaucrats. They don't even know how to conduct an administrative hearing. And let me tell you, there's another book that's extant that we really recommend. Now, we don't necessarily produce all these books. There's a fellow down in St. George, Utah, named Mann. What's that man's name? Walter Mann, I think his name is. And it's called Mann's Book. And I don't know the man personally, and I'm not here pushing his book. It's fairly expensive. It's $200 or $300. But we've gone through that book with a fine-tooth comb, and let me tell you, that man has done a tremendous amount of research on administrative law and procedure. He's exactly correct. Now, I haven't written a book like Mann's book, and since it's already written, why would I want to write the book? It isn't necessary. The information's there. What you do is you go into these IRS hearings, you get into these State Tax Commission hearings and demand all of your rights. There's a whole body of law, by the way, from the Supreme Court. You know, you have to go through these administrative law hearings and demand your rights. You have to go to the traffic court. I'm not telling you to stay out of there. You go out to the traffic court and you lay these constitutional demands and all this paper on this poor traffic court judge who's nothing more than a clerk. He's probably a layman. In this county, in this state, many of the lower court judges aren't even attorney magistrates. They've never been to law school. Boy, they're just political appointees, political hacks in judicial robes. And you walk in there and you demand a grand jury, and the guy looks at you like, huh? You can't do that in here. He doesn't understand the law. And these bureaucrats up at IRS, I've never met an attorney at the IRS. They're all accountants. They've all been to college. They're all screwed up. They can't think. No, wait a minute. If you've been to college, I don't want to offend you. I'm just telling you that, you know, I'm an employer. I'm a 12th grade dropout from high school, and I hire college people year in and year out. And the one thing that I noticed about college that really screws people up is you go to college and you major in accounting. And when you get out of college, that's all you can do in life is account. You can't eat because, you know, yeah, that's right. You can't eat. You can't determine your medical problems. You can't determine your legal problems. The only thing you're qualified to do is account. Now, boy, you take an accountant out of college, and I'll tell you, boy, there's a guy that can add and subtract. You take a medical student out of college, and there's a guy that really knows medicine. You take a lawyer out of college, and boy, there's a guy that may or may not know the law. But what happened to the well-rounded individual who has a little knowledge about eating? You know, I haven't been to a doctor in 25 years except for an examination a couple of times for my third-class medical for my pilot's license. I wouldn't go to a medical doctor for treatment if you paid me to go there. That's what I think of them. I'm not telling you medical doctors are bad. I'm just saying that's my personal opinion. I've done a little research on the subject of medicine and law and accounting, etc. My observation is I'd hire people out of college and they'd get divorced and they couldn't run their families and they just really have problems in life. Well, that may be an aside, but I'll tell you, it's a real root, core, causal, cause and effect problem in our society because we've got these specialists out here. You try to get due process of law and equal protection of the law from the IRS. It isn't possible. There isn't anybody there that even understands what you're talking about. You go into IRS and you tell them, I want my Fifth Amendment rights and guarantees, and I don't want to make any statements, admissions, or confessions. I'm demanding probable cause, and where's the specific performance demanded by the contractual agreement pursuant to a penal clause in the contractual or quasi-contractual arrangement? And the guy sits there and goes, what? Huh? That's where they're at. So you go in there and you make these constitutional demands and you do it in front of witnesses and you get the evidence. Then when they deny it to you, the question isn't why didn't you pay your taxes? The question is why did you deny this man a meaningful hearing and due process and equal protection of the law? That's the way you go in and do that. Now, if you've really handled yourself correctly, you don't have any income and you don't have any income tax, and so you don't go into the IRS anyway. Say, I don't even get letters from the IRS. They don't bother me at all because, you see, I don't have any income and I left the system orderly. I'm not out here waving red flags, you know, with Fifth Amendment returns and nasty letters and challenges and common law liens and things like that, you know. That tends to stir up a lot of problem. I'm not saying they're all bad, wrong, terrible, wicked, and evil. I don't know about you and your case. I'm just telling you that my common sense told me that when I wanted to leave the tax system that I ought to do it without making a lot of waves, and if I slipped out and nobody missed me, I'd have less problem, and I'm having a lot less problem. The last clause, then, of your Fifth Amendment here is, nor be deprived of life, liberty, or property without due process of law. Now, that goes into the 14th Amendment. Nor shall private property be taken for public use without just compensation. Let me tell you, you're going to have your property seized by the tax people, your cars and your motorcycles and boats seized by your law enforcement people, and they're not going to do it with just compensation. They're not going to do it through the process of eminent domain and condemn it and then pay you for it. They're just going to steal it. And when your policeman steals your car, there's two actions. It's called a replevin and a trover. That's the way you get to the policeman and the towing company. Probably in your county you've got a system of theft going on there by your police and these other criminals known as city councilmen and what else do we call them here? We call them county commissioners passing ordinances and county ordinances. And you may even have some criminals up in your legislature passing these things called statutes. And when they do that, it's called legalized theft. It's illegal and unlawful without your permission or consent, but most of you have probably given them your permission or consent, and so therefore they're doing it legally and lawfully under the Constitution. And they do that, you see, when you have a driver's license, and then they pass statutes, and they say, well, your car was abandoned alongside the road, so I had to call the Ajax Towing Company to tow your car in. I didn't abandon it. You arrested me and took me to jail. Well, it was there, and I just acted under Statute 49-404, and I'm just doing my job. You see how that goes? Now, what I do is I always put my car on private property. When they steal it, they have to steal it off of private property. So when the policeman's behind you, don't park alongside the road. Drive down the road until you get on somebody's private property. Boy, I really like it when I've got witnesses in my car. If you don't have witnesses, always take a tape recording. Yeah, that's right. They'll break your tape recorder and they'll tear up the tape, but then you can always ask them questions on the witness stand as to what happened to that tape recorder. And what happened to the tape. And in our county, you always ask the policemen. See, our policemen in our county, and always be aware of this, they always have right here on their belt, they've got a little tape recorder and they've got a microphone right up here, and they're taping everything you're saying. They're there trained to gain admissions and confessions. You see why when I'm at the scene of the crime and the policeman says, what's your name? Who in the hell wants to know? And who are you? Identify yourself. He's a public servant. He identifies himself. He carries a little badge here and he says, Officer Smedley. Maybe I'll identify myself and maybe I won't. Depends on the circumstance. If I don't want to go to jail, I'll tell him, yeah, my name is Joe Baloney and I live at 1205 Jones Street, and I'll sign your ticket under threat, duress, and coercion, and I'll see you in court. Sometimes I do, sometimes I don't. Depends on how I feel that day. Now remember now, you've got the Fourth and Fifth Amendments, and they have been ruled upon numerous times by your Supreme Court. What are those two books that you need to read, study, and understand? Search and Seizure Law Report. Go to your law library. Ask the librarian. I need the Search and Seizure Law Report. You can subscribe to it. It costs you $36 a year, I believe, for the Search and Seizure Law Report. It's only 8 pages. I'd rather go to the law library and copy it for 15 cents a page than I would to subscribe to the thing. Your law library has it, and you can get it. You need to study 100 of those cases. What's the second book I told you needed? Words and Phrases. It's a whole series of books, 10, 15 volumes, and they're about this thick. Let me show you a book, 10 or 15 volumes. Words and Phrases is crucial to you because it's the Supreme Court's decisions, and it's an easy referenced way to find out what has the Supreme Court decided on a particular subject. Social Security. Look up the word Social Security. 132 times since 1935, which is the year the law was passed, the Supreme Court has ruled on it. Who's eligible to get benefits? Is it a right? Do you have to belong? How do you get out? Has anybody ever tried to get out? Has the Supreme Court ever ruled? What happens to people who move to Poland? Can they have their Social Security benefits cut off? Is it a privilege or a right? They've ruled on that subject matter. If you want to know about Social Security, why don't you go ask the Supreme Court? Because they're the final authority on that subject. The Congress passed the law, but the final authority is the Supreme Court. The President probably proposed the law, and the President is probably executing it with his agents. The President is probably violating and breaking the law every day. The final authority is the Supreme Court. Why don't you go right straight to the horse's mouth and get it right out of that court's mouth? Then when you fashion your lifestyle around that Supreme Court case, why don't you want to drop out of income tax, why don't you read Hale versus Hinkle? And when we get to lesson 24, I'm going to show you about the income tax and how to get out of it and why you're in it and et cetera. But assuming that you want to get out of it, don't you want to know how the Supreme Court has ruled? What is income? What is a source of income? Who's required to file? Who's required to pay? What kind of a tax is it? Is it direct? Is it indirect? Is it excise? Is it income? Those questions have all been answered. I can't think of a thing that the Supreme Court hasn't already talked about. Now, there may be some things, and that's called new ground. But basically, there isn't anything that they haven't already decided, at least once or twice, on every word in this Constitution. I'm telling you, everything in here, somebody at some time in the last 200 years has said, hey, I think this violates this, and I think that violates that, and they've made some decisions. Some of the decisions you may not agree with. There was 2 or 3 of them. Out of the hundreds of cases I've read, I've disagreed with the Supreme Court, I think, 3 times. I'm really not competent to disagree with them many more than 3 times. William O. Douglas disagreed with them about half the time or more and wrote very vociferously on all of his dissenting opinions about what he thought. So I'll leave it to you. You've got as much wisdom, reason, logic, and common sense as I've got. What I would like to tell you to do is don't believe what somebody else tells you. What I'm telling you is go right to the horse's mouth. And that's the Supreme Court. Don't believe what I tell you. When I tell somebody something, I tell them because it's here, it's in this case, it's in this lesson, I've researched it, I've put it into the court, this is what works. And that's what I'm telling you that you should do whenever you're listening to anybody else. Give them the courtesy of listening to their position, but when you're listening to the position, always reserve that right. Let me check it out, just to be sure. Let's take a look now at the Black's Law Dictionary and see what the exclusionary rule is by definition. We don't use Black's Law Dictionary too often, but the older dictionaries, that is Bouvier's 1870 Law Dictionary, doesn't have the exclusionary rule in it because the first case that was decided in this long list of cases called the exclusionary cases started with Boyd versus U.S. in 1876. And we'll look at the Boyd case and the Weeks case, and while I'm not going to read them word for word for you and go through them item by item, I'm going to take some selected exclusionary rule cases and take you through them to introduce you to a new experience that you've never seen before in law.